Good evening to everybody. Good evening to our guest of honor, Ms. Ruchi Negi ma'am. Your presence here is highly appreciated. I would also like to extend my heartiest thank you to me, sir. Your vision and this platform has provided me and many before me the opportunity to present their ideas so seamlessly and in our comforts. I will also like to thank the coordinators, Samriddhi ma'am, Manvi and Shailendra for their coordination, guidance, and advices so that I can navigate through this really well. Um, Introducing myself, as Shailendra rightly said, I am Drishya Nair. I completed my graduation from Bharati College, Delhi University. Right now, I am pursuing a master's in African Studies from Department of African Studies, Delhi University. Today, I'll be talking about violence, legal language, and judicial interpretation, where we'll be exploring various aspects of violence, types of violence, legal language. I'll be delving you or making you go through three case studies where we'll be going around three continents, uh, from Rwanda to United States to Myanmar. We'll be concluding it with giving you an overview of how the lacuna in judicial interpretation due to the complexity of the language leads to violence. Before starting the topic, I would want everybody to know how I got to this topic. Uh, so basically, what led me to this topic is the current geopolitical environment in the world. आज हम बहुत कन्वीनियंटली अपने घर में बैठ के बिकॉज ऑफ द ग्लोबलाइज्ड एनवायरनमेंट हम ये जान सकते हैं देख सकते हैं कि अलग अलग देशों में क्या क्या चल रहा है इट्स अ गुड थिंग एज वेल इट्स अ बैड थिंग एज वेल बिकॉज हमें पता चल रहा है कि रशिया यूक्रेन में पिछले 1.5-2 साल से वॉर चल रहा है इसराइल में वॉर चल रही है पैलेस्टाइन में द अमाउंट ऑफ वायलेंस दैट इज अनफोल्डिंग इन पैलेस्टीन all of which is did lead me to take a look into violence, the nature of violence, and how it is manifested in society. Thus, the topic which you could all see here. The presentation will be looking into the aspects of violence, how violence and legal language has to be juxtaposed during a judicial interpretation. Such juxtapositions has to be made in the backdrop of the nature of society in which it occurred and the time of action where it happened. So, before because of the I understand that legal language is a little complex thing to start off with. Therefore, I would like to give you all extract into to make you a little more enthusiastic about this topic. Let's talk about the Land Reforms Act of 1950. So basically, जब Land Reforms Act of 1950 post independent India में introduce किया गया, the entire agenda was to make people of India economically capable. वहां से ताकि इकोनॉमिकली सब लोगों के पास पैरिटी हो सिर्फ लैंड कुछ लोगों के पास ना रह जाए इस जो अंडरस्टैंडिंग है इस जो नोबल आइडिया है ये वाली आइडिया को लोगों के बीच लाने के लिए लैंड रिफॉर्म्स एक्ट ऑफ 1950 लाया गया था बट दैट इज नॉट हाउ इट मैनिफेस्टेड इटसेल्फ बिकॉज लैंड रिफॉर्म्स एक्ट के अंदर जो लैंडलॉर्ड्स थे उन्होंने अपने किथ किन और अपने सर्वेंट्स और उन सब के नाम पे लैंड कर लिया एंड बाय फोर्स और बाय maybe navigating or negotiating some negotiation they did it under there but that didn't end up happening so well for the state because at the end of the day the entire idea of economic parity was defeated very well. There were reports जहाँ पे house arrest बताया गया जहाँ पे servants were brought into the landlord's house and they were kept in the house for long durations. There were violent acts against them. These all indicate how a very noble law, because of its misinterpretation and misuse by the few in power, led on to violence, which is the entire idea of today, or which is the entire idea we would be talking about today. So, We'll be talking about various aspects associated with law and how law, legal language, has a gap between two which has to be understood by juxtaposing each other. We have to understand the nature of law and how the law evolved in the cultural context in which it evolved in. We have to, I would like everybody to understand it in a sense ki how legal language and legal interpretation further leads on to violence. That's the entire aim of today. Moving on to the first thing, what violence is. Violence kya hota hai? So World Health Organization, again being an international organization, gives us a fantastic example which encapsulate everything. So, the international use of physical force or power, threatened or actual, against oneself, another person, or against a group or community that either results in or has likely root in resulting injury, death, psychological harm, or maldevelopment and deprivation. That's what World Health Organization has defined what violence is. But while defining violence, one has to understand that it has both moral as well as material consequences. Whether or not a perpetrator is prosecuted, the legality of the interpretation, and how this legal language is implied upon, that has to be understood in its fullest conscience. World Report on Violence and Health has divided this entire concept of violence into two broad aspects based on किसने वो किया है और वो कौन सा नेचर था उस जो वायलेंस जो हुआ है उसका नेचर क्या था उस पे. So, based on who did it, it is divided as self-directed, interpersonal, collective. Whereas जो उसका नेचर है उसके बेसिस पे उसको सेक्सुअल, फिजिकल, साइकोलॉजिकल एंड निग्लेक्टेबल वायलेंस के categories में किया गया. But one has to be cognizant of the view that all of such categories are not exclusive. वो सब एक साथ आकर एक ओवरवेलमिंगली इंटरलोकस एनवायरनमेंट में किया गया है और उसको उसी तरीके से अंडरस्टैंड किया जाना चाहिए. Pat Shipman, one of the psychologists, has went on to tell us what violence is according to him. He says कि ये हमारी बायोलॉजी के अंदर ही एनग्रेव्ड है, ये हमारी अंडरस्टैंडिंग के अंदर हमारे डीएनए में ही है. हम प्रीमॉर्डियल एरा से ही उस चीज को हमारे खून में वो चीज है, as it's in a very simplest and natural way. And he proposes a idea against it where he says कि हम इसको कैसे टैकल कर सकते हैं by moving towards a greater us. The idea of towards a greater us is very well manifested in international organizations such as the United Nations Organization, NATO, European Union, Asian Conference of Parties, which is dealing with uh, uh, one of the most heated arguments of geopolitical world, that is environment and sustainable development. So all of this in view is they are fighting against issues like terrorism, which is a very virulent form of violence. But one has to be very, very mindful of the fact that legal violence does not always takes place फिजिकल फॉर्म में या फिर ऐसे हार्डी फॉर्म में जहाँ पे एक दूसरे को मारा ही जा रहा हो. रादर उसको वायलेंस में इट डज नॉट लॉ के कैपेसिटी में ही वो एक चीज होती है जहां पे इट इज इम्पोज्ड एज पेनाल्टीज, इट इज एनफोर्स्ड एज कंप्लायंस और लेजिटिमाइज कर दिया जाता है यूज ऑफ फोर्स ताकि हम वायलेंस को जस्टिफाई कर सके इन एन इंस्टीट्यूशनलाइज्ड फॉर्मेट. There are various types of violence where physical violence जहाँ पे एक दूसरे को मारा जाता है, psychological violence such as those women who go through domestic violence जहाँ पे because of domestic violence people have a lot of mental turmoil, sexual violence, a part and participle of genocidal violence or massacre. When India went through partition, there were sexual violence and rape culture so virulent and so engraved in the society that people are writing profoundly about it. Domestic violence, everybody by the nature of it, it is very self-explanatory. Economic violence, which we can see in today's world, Sri Lanka and maybe Bangladesh. Uh, these states are undergoing violence because of the economic situations in the country. There are cultural and structural violences. Cultural violence is because there is cultural difference, which we can see in Israel Palestine, जहाँ पे because of the ideological differences between these two Abrahamic religions, they have led on to violence. But one needs to understand that violences which are very new in nature, such as cyber violence, which is come into force in 21st century, is a resultant which doesn't manifest itself in legal text, because most of the legal text which we read today, आज जो हम legal text पढ़ते हैं, it is written either in 70s, 80s, 50s, 60s. So it has to be revamped. It has to be reread with the same ideological mindset. Moving on to what language is. Language has its own purse. Take it from me. I am from a South Indian state coming to North India. I understand what the importance of language is. Language is not just a medium of talking. It's not just a medium of transmission of your ideas and thoughts. It's also a medium of transmission of your emotions. It is the medium of transmission of your entire culture. So language doesn't just limit itself to what is written in the text. It doesn't limit itself there. It has to be understood in that entire complex arena of it. It is this legal language in itself is characterized by um, a lot of formality to it, statutes, documents and proceedings, जो judges predicaments देते हैं वो सब. So it has a very complex structure to it, which requires a very mindful and complex interpretation to it as well. Aspects of legal language. There is precision and ambiguity, specialized terminology such as plaintiffs, defendants, formal structure to it. There should be there is consistency and repetition so that we don't confuse ourselves by the saying of the words which is written there. It has a very declarative nature to it, which again enforces ideas which are very formal. Then legal language is typically devoid of this personal tone or colloquial expression, emphasizing neutrality and objectivity, which is the entire point of my argument. That because it has this personal touch to it, because it is not able to connect itself to the people, it loses the entire agenda. The entire state structure is structured in those elitist ideas and forgo the day-to-day problems of the common people. Moving on, the interpretation of legal language. So legal language basically evolve यूरोपियन वेस्ट सेंट्रिक व्यू में ही हुआ है, जो यूरोसेंट्रिक व्यू के हम जो एकेडमिक वर्ल्ड में बात करते हैं. It either is a common law system UK US का, or it is the civil law system that we see in France and Germany. The UK law system is talking about the judge's discretion. वहाँ पे judge का personal interpretation of that particular law has much more importance in contrast to the civil law system, जहाँ पे it is basically more code based, focusing on the statutory text में जो लिखा हुआ है उसके basis पे. Whereas we see the fourth law, which is the Islamic law, which is getting its roots from the religious text, जो बताता है डिवाइन प्रिंसिपल्स और jurisprudence स्कूल ऑफ इस्लामिक लॉ के थ्रू जो आता है उसके बारे में बात करता है. So we have to understand the entire point being these variation and interpretive methodologies reflect broader cultural, historical, and psychological differences that influence how laws are crafted and applied across the globe. That is to be understood in its purest form. This being said, there are various methodologies involved such as textualism, जहाँ पे आप text को direct समझ रहे हैं, originalism, the environment in which it originated, the purpose of which it originated in, Then constitutional interpretation, dynamic interpretation, all of these are methods to which a legal text is interpreted. The first and most interesting case laws among all, the Rwanda genocide prevention laws. So when 1994 Rwanda was facing civil war and genocide, it catered to some prevention law so that such genocidal tendencies should stop. But rather than doing that, what happened was these prevention laws catered much violence in Rwandan society. As you can see in the PPT, the purpose was to stop the genocidal ideology, but that didn't happen. गकाका कोट्स जैसे आज अगर वी हैव टू ट्राई एंड ड्रॉ पैरेलल बिटवीन इंडिया एंड रवांडा, आज हम पंचायत राज सिस्टम में जहाँ पे हमारे 5 पंच बैठ के जो ग्राम पंचायत है वहां पे बैठ के विलेजेस के जो इश्यूज है उनका सोल्यूशन ढूंढते हैं, वैसे ही गकाका कोट्स is a tribal form who used to come in and find solutions for the issues, which was replicated after the genocide in Rwanda, where these Gakaka courts were brought in to reduce the dependence on the judicial system then, because of the humongous number of petitions which were filed against by these people who face the genocidal issues and stuff. So उन्होंने petitions डाली, उन्होंने बात किया, they wanted justice for themselves. So what these Gakaka courts did was around 12,000 Gakaka courts were hearing 2 million cases. In this in itself showcases that गलती होने की chances बहुत ज्यादा थी. Many individuals were falsely accused of participation in genocide, leading to social tension, and in some cases it was also lead to retaliatory violence. There were violence against these witnesses. Around 500 witnesses between 1999 to 2007 were murdered because they were witnesses in these Gakaka courts. Prosecution under this genocidal ideology, an estimate says that around 12,000 people were prosecuted by 2010. So there were localized violence as well. These numbers showcase how an issue, how a law which was basically formulated कि हम genocide कम करें, but it was leading into further violence. आप इन pictures में देख सकते हैं that a small boy's ankles were cut down so that he could not walk anymore. These children are waiting for the aid people so that they can have some food. That is the condition. That is how violence manifests itself in the society. Moving on to the next continent, that is US, where Jim Crow laws were implemented. So it was basically a law for racial segregation in southern United States to maintain racial inequality by defying the African Americans the same rights and privileges as were of the white Americans. So Jim Crow, which you can see on the image on the PPT, that is what Jim Crow is. It is a blackface ministerial character used to mock the African Americans. But these Jim Crow laws actually led to multifaceted violent clashes, where around 4,700 people were lynched and 73% of them were actually African Americans. So these laws actually led to widespread discrimination and social inequality in the society. Last but not the least, Rohingya crisis in Myanmar, a neighborhood state जो हमारे बगल में ही रहते हैं. A lot of migrants from Rohingya are in our state itself. So it's a very big humanitarian issue where laws, discriminatory policies, and systematic execution have contributed to widespread violence against the Rohingya Muslim population. Our data says that around 1.3 million Rohingyas have fled Myanmar and went into refugee camps in Bangladesh and India. In 2017, during the time of peak military crackdown, it is estimated that 6,700 Rohingyas were killed. Uh, Again, a destruction, the destruction, the amount of destruction that we can see by 2016 to 2017, around 300 Rohingya villages were razed to ground, and that shows the amount of violent issues which one law or one क्या कहते हैं, jurisprudent declaration could bring in. That's the girth of it. In at last, what I would like everybody to go on and give you a thoughtful insight upon is that a punishment is meant to bring deterrence and incapacitation, rehabilitation, to reintroduce the person who has been punished into the society afterward. But the entire idea is defeated by now. A lot of laws are brought into place by the powerful elites, which forgo the idea of it completely. It is important to understand the nature of crime and the nature of punishment, and to the extent to which this punishment would inflict harm to the social fabric. And that being said, I rest my case here. Thank you.
Thank you. Thank you very much, Ms. Drishya, for such a wonderful depiction of your topic. It was really very good, and law and different interpretations, some different historical concerns, so many instances, and you segregated each one and you explained every bit in a very in a very structured way. So it was definitely a great session. We have some questions, so let's take them. So the first question I'm taking, and the question is that after such an in-depth analysis of so many different instances, what do you think are the implications of these variations in legal languages across different jurisdictions on international law?
Sorry, can you repeat the question for me once again?
Okay, for sure. So the question is basically कि, after certain in-depth analysis of different instances which you have given, what do you think are the implications of these variations in legal languages across different jurisdictions on international law?
So basically, because of the ambiguities in understanding law in its in-depth, and how in a particular society the law is evolved, sometimes the way it is interpreted, because basically what common law system or civil law system has given us is it's a colonial heritage which we have today. So because of the colonial heritage, we have this tendency of replicating. We do not are not very cognizant of the issue that violence or the legal language, the society in which it evolved, has have various amounts of issues with it. That being said, uh, we have a lot of issues with the amount of uh, people who have interpreted it. People have different ways of interpreting, and the societies have different ways of interpreting. So sometimes these all interpretations have to be brought together, and in a global platform, because we do not have one powerful state, or because we do not have a central authority, these legal languages, interpretations, implementation in different countries differ variably.
Okay, rightly said. Now, the next question is sometimes legal laws also led to violence. And in that case, what move one should take to neutralize the impact of violence occurred due to laws?
So obviously legal laws, as I said, leads to violence, but to neutralize such violence, it has to be the state has to be very much alert. The state has to make laws which are in align with the cultural, which psychological, and the global mindset during that time. At the same time, other foreign actors have this tendency of influencing the state which is undergoing such turmoil, and make best use of it both in economical and psychological terms. So one has to be cognizant of the view, and one has to work its ways through it. Such violence can be reduced by state intervention, and if state is unable to do it, foreign powerful institutions should come in and work with the state to resolve such issues.
Okay, okay, all right. Now, last question I'm asking is how does judicial interpretation evolve with societal changes, particularly regarding laws related to violence?
Judicial interpretations change with violence, and actually should change with violence, because violence, along with the destructive view it brings, it also brings a lot of experiences with it. Sometimes state has not gone through the amount of issues which it grows through when it undergoes a turmoil, maybe political, economic, psychological. So it has to be understood that every state should uh, work in its view. I'm going against the question. Can you repeat the question once more?
Okay, okay, wait. So the question was that how judicial interpretation evolve over the societal changes, like according to the societal changes.
Yes. So the judicial interpretation changed according to the society, as if like when Jim Crow laws were implemented, it led on to racial segregation of the whites and the blacks. It was also a resultant of the. It was basically in southern United States. It was in southern United States because southern United States was the hub where this after transatlantic trade, slave trade, after transatlantic slave trade, these slaves were brought in and they were put or dropped there. So, but after the Jim Crow laws and how after the reaction of it happened, people were understanding after the violent turmoil, a state of calmness was brought in, and such laws were banished, and such racial segregations were repatriated, and state tried to include these black people in their society. So such laws were proactively defeated, and new laws where inclusion and addressing major issues are brought in uh, should be are examples where culture and psychological things brings change.
Okay, okay, all right. I could see one more question into the chat box, so let's take that too. So the question is, how do you think that laws on violence impact marginalized communities? Like, do laws impact them differently? And if it is so, then why?
So yes, definitely laws on violence impact marginalized communities differently, because by the nature of being marginalized, they do not have the amount of resources and amount of links that could help them evade it. They are already focusing on much important things of daily wages or how to survive through the day. So such marginalized people do not actually have resources which would help or play for them. So these are the first one who take the hit of such loss. These are the people who have to face the in-depth issues which such violence erupts, because as I said, violence is not just one issue. It has multifaceted formation. It just is not one issue. It can lead to communal violence. It can lead to ethno violence, and such violence are replicated in different society differently based on the nature of that violence or how such violence has evolved or come into place.
Okay, okay, very well answered. Now, the last question, which we always ask to our speakers, and the question is that how was your experience with this platform throughout the week? So, would you like to tell something about that?
Yes, I have. It was a fantastic experience. I have had Manish sir and Manvi Samriddhi ma'am with me all through the week, and we were trying to make it more interesting because of the nature of the topic. It's very methodological and very it is very it's not that much of fact led, and it doesn't lead to very much of it needs a lot of attention for the listener to understand it. Hence a lot of ideas and datas and lot of a amount of questions and questionnaires and back and forth we went through how we have to present it. It was really seamless, and all my questions, queries were answered in very rightful and very positive way. That was my experience. Thank you.
Thank you so much, Ms. Drishya. Once again, congratulations for such a wonderful depiction today. Now it's time to invite guest of honor, Ms. Ruchi Neki ma'am, for her final remarks over today's topic and over today's title. So, ma'am, please.
First of all, I would like to congratulate Ms. Drishya for her insightful, well researched, and really well spoken presentation on how land and law and violence, can be entangled in complex ways. So, law, what is its primary objective? It is to maintain order, protect rights, and ensure justice. At the core of law is its relationship to justice, equity, and collective will of society to live in harmony. On the other hand, violence, it disrupts peace, it often leads to chaos, bloodshed, and it directly contradicts the very essence of law, which is designed to uphold peace and order. So, at first glance, law and violence may seem antithetical. After all, law seeks to prevent violence and protects individuals from harm, right? However, history tells us how complexity occurs when the law is misinterpreted, manipulated, or selectively enforced to justify or escalate violence. जैसे कुछ एग्जाम्पल्स हैं, दृश्या ने ऑलरेडी स्टेट कर दिए हैं. जैसे साउथ अफ्रीका का हम बता सकते हैं, वेयर अपार्थीड वाज अ लीगल सिस्टम बेस्ड ऑन रेशियल सेग्रीगेशन enforced by law from 1948 to 1994. So what we saw in South Africa was not the absence of law, rather the deliberate misinterpretation of legal principles to serve a small minority, the whites, leading to a systemic violence and oppression against the blacks. Similarly, during the Nazi regime, laws were explicitly designed to oppress Jewish people and other minorities. In fact, the Nuremberg laws of 1935 are a prime example how legal frameworks they were used to justify widespread violence, including the genocide in Germany. The US waged a war on terror right after 9/11 happened, wherein the US government they introduced laws. One of these laws were the Patriot Act, which allowed for indefinite detention of suspects without trial. So while the intention was to, of course, curb terrorism, these laws were interpreted in ways that justified human rights violations. The use of torture in Guantanamo Bay, especially, where drone strikes had killed millions and millions of civilians, show how the misinterpretation of national and international law can lead to violence. The recent examples of Israeli-Palestinian conflict, it provides another complex case. Here, both sides, they have cited legal and historical claims to justify violent actions. International law has been interpreted in multiple ways, particularly regarding issues like the right to self-defense, territorial occupation, and human rights abuses. Another example, in fact, of the misuse of legal language, like the right to defense, can be seen in the case of Russia's invasion of Ukraine. So Russia justified its action under a very distorted interpretation of the right to self-defense and the protection of Russian-speaking people in Ukraine. So in all these examples, um, law or legal language, has ceased to be a tool for justice and has instead become a weapon of oppression. A common pattern, if you can observe, or that emerges in all these cases, is that how those in power manipulate the law to serve their interests while undermining justice. So this blurring of the line between legal justification and moral wrongdoing, it deepens societal fractures. And also the world that we live in today, where technological advancements are there, social media is there, they have made it quite easier to spread misinformation about legal frameworks, further accelerating violence. We have to prevent this misinterpretation of law and the legal language, so to speak. And for this, we need a stronger legal education system. I feel one of the best ways to combat the misuse of law is through education. Educating the civilians about their rights and obligations is a must. At the same time, the international bodies like the United Nations and the ICC, which is your International Criminal Court, they must have more authority to investigate and penalize violations of international law. Also, I feel law cannot be just left in the hands of a few. It's important that there is judicial independence, free press, and civil society. They must work together to prevent authoritarian or totalitarian regimes from bending legal frameworks to justify violence. And then finally, we need a comprehensive peaceful conflict resolution over legal justification for violence. This means that we need stronger diplomatic efforts, we need mediation, we need dialogue between conflicting parties, whether it's on the international stage or it is within the nations. So not taking much of your time that I already have, I'd like to conclude my remarks by saying that while law is intended to serve as a pillar of justice, peace, order, its misinterpretation can lead to violence, bloodshed, chaos, and oppression. So the examples that we have discussed today, from apartheid to contemporary conflicts, they reveal the deep interconnection between law and violence when the former is especially misused or misunderstood. So as responsible citizens and scholars, we must continue to scrutinize legal frameworks, we must advocate for fairness, and we also need to ensure that laws, they serve its true purpose, that is the promotion of justice and peace. Thank you so much.
Thank you. Thank you so much, ma'am, for all your suggestions and insights about today's topic. And thank you so much for joining us today.
I would like
Now,
to intervene. I'm sorry. I would like to extend my gratitude to Professor Nachiketa Singh, who is the principal of Shyam Lal College, IQAC convener Dr. Dwivedi, GSTS convener Dr. DN Singh, and a big thank you to our beloved and respected Manish sir and the wonderful team of GSTS for this amazing opportunity. Not only was I able to share my thoughts, but I also gained valuable insights from the students' perspectives. And I wish this platform, it continued success and growth, and may it reach even greater heights while serving as this useful space for today's youth to express their opinions so freely and confidently. Thank you so much.
thank you, ma'am. Thank you so much for your such a lovely wishes. Thank you so much, ma'am. And now, proceeding the session further, it's time to invite a to-be speaker for next Sunday. Now, I would like to invite Ms. Palak for presenting her objectives for her upcoming talk. And the talk will be on the topic turning scams into lessons. So, Ms. Palak, you could present your objectives.
Hi everyone, good evening. I am Palak Punchi and I am currently pursuing my bachelor's in commerce from Ram College, University of Delhi. I am someone who is deeply passionate about finance, which brings me to the topic that I will be speaking about next week, which is turning scams into lessons, SEBI roles in rebuilding trust and empowering investors. So now my objective for the talk would be: first will be the understanding scams. What are the various types of financial scams in the stock market and how they operate? This will include discussing real life examples to illustrate the impact of the scams on investor. Second, the role of SEBI in regulating the securities market in India. This will include discussing how SEBI works to protect investors, enforce regulations, and promote transparency in the financial system. Third will be rebuilding trust. This will include focus on the importance of rebuilding trust in the financial market after scams. This can involve discussing initiatives taken by SEBI to restore confidence among investors and ensure a safer environment for the investment. And the last would be learning from the past mistakes. This would include discussing how both investors and regulatory bodies can learn from past scams to prevent future occurrence. So, on and all, it would be a session that would bring a lot of education, awareness, and empowerment, all of which are essential for fostering a healthy financial ecosystem. I am so excited to share this learning space with all of you. I look forward to seeing you next Sunday. Thank you.
Thank you. Thank you so much, Ms. Palak. And we'll surely join you. And I'm also inviting you all on her behalf. Kindly join us on next Sunday, where Ms. Palak will be addressing 190th GSTS talk session. So thank you once again. And now it's time to wrap up this another beautiful evening. Thank you everybody for connecting with us today and for wrapping this session up and for giving vote of thanks. I would like to hand over the moderation to Dr. Manish Karma.
Uh, Thank you, Salendra. Now, I'm having 1000 seconds. Okay. So I can utilize all those seconds with invites a few of my students and faculty members. And after that, I'll give my final remarks about the talk and the wonderful evening. Two of my young scholars given their ideas about the very balanced idea about the legal laws and the violence, because these are the very two very hot and controversial topic, but the way you people are carrying all these topics, it's really wonderful. So firstly, I would like to invite our colleague from Samlal Evening College, Miss Akriti. Akriti, if you want to say something. So, Akriti, over to you.
Hello, good evening, sir. Thank you so much, sir. So it was a really wonderful talk, and it was a really very interesting topic because I'm also dealing some part of law related to my research. So even in context of India, as a it's been a colony. So I feel that I was following the works of Radhika Singha and others who actually has worked on law. So in Indian context, it was like a cultural interpretation, like the colonial law based on Indian native legal system. But in context of America and Africa, it was very different. So I don't think we should, generalize the legal system. It has their own specificity according to the landscape. So all in all, it was a very interesting talk, sir. Thank you so much for giving me this time.
After very long, our teacher in charge, DN sir, with us, sir. आप कुछ बोलना चाहिएगा, DN sir?
हाँ जी मनीष कुमार जी
Sir, thank you for joining after long.
अब
Yes, sir.
ऐसा है कुछ ना कुछ प्रॉब्लम हो जाती है और एक रिस्पॉन्सिबिलिटी तो है कि मतलब अम, एक इंचार्ज की हैसियत से और जीएसटी कन्वेनर की हैसियत से तो आप याद दिला दिए हैं। वैसे मैं आई विल ट्राई माय बेस्ट टू ज्वाइन इन फ्यूचर और दिस शुड कंटिन्यू। और ये बड़ा अच्छी बात है जब 100 एपिसोड का सेलिब्रेशन चल रहा था एट दैट मोमेंट की इट हैड क्रॉस द बाउंड्रीज ऑफ यूनिवर्सिटीज स्टेट और यानी कि जो फील्ड सबको टच किया। द क्रेडिट गोज टू मनीष करमवार और एक शानदार चल रहा है और भविष्य में मेरी शुभकामनाएं रहेंगी और आई विल ट्राई टू ज्वाइन every episode in future. So, okay. Thank you, Manish Karwal,
Thank you, sir.
and all
Thank
the
you.
organizers
Thank
of
you, sir.
GSTS. Okay.
Thank you, sir. And with us, we are having one of my favorites, Professor Sambhuna Dubey, sir, and he's a political scientist and activist. Every day he counters with the law, legalities, and not violence actually, but the violence is a different type of violence. Sir, if you want to say something, Sambhu, sir.
Thank you, Maniji. Though I joined late today because I was just unaware of the timings. When I joined, speaker had hopefully winded up, and I was just listening to Professor Negi, and very beautifully she was trying to sum up the entire discourse on legal recourse, the situation which we are coming across at present, and some of the situations which has a long historical past as far as its legal implications are concerned. So I really appreciate the way she was trying to present her views on the topic. And I did get an opportunity to learn few of the things as far as this topic is concerned. Thank you all for the tremendous effort and hope to join all the sessions in future also. Thank you so much.
Thank you, sir. Thank you, sir, for joining. Uh, and I would like to invite one of my student, Raghav. Raghav, if you want to say something about uh, this topic, so go ahead. And you are having 60 seconds, Raghav.
Yes, Professor. So, I mean, first of all, thank you, Drishya, for that incredible presentation. This was not a topic that I was familiar with. I mean, I'd heard about, things happening in Myanmar and all. So that sort of like an in-depth sort of insight uh, was really appreciated. And yeah, like the legal interpretations in these topics is not something that I had covered. So, I mean, I might be repeating myself, but it was really informative and I really enjoyed the insights. Thank you.
Thank you, Raghav. Okay, so it's my final remarks about the topic talk and the idea. So the first thing that was from the violence to a scam. So thank you, Drishya, for your wonderful presentation and a depiction about your own thoughts, because I had a conversation with you and you told me that I'm in the primary stage of my work, but you have presented very well, though still some examples are missing, but it's perfectly fine to understand, because today you are very articulated and very nuanced when you started your understanding how you up this topic and what's the idea behind all these topics. So thank you, Drishya, for your effort, for your ideas about the violence, and as well as the guest of honor, Miss Rushi Negi, and I know her from last 1.5 years. So definitely, you have given us a broader range what this are told, and you have expanded that horizon towards the other examples also. So what I feel that Divya, Drishya was missing, you have covered up. So thank you very much. My two young scholars, Drishya and Ruchi, and in this sense, the African studies in the good hands. Fortunately, this is not the forum of African studies, but the speaker and the guest of honor, those are somehow related to the African studies. Okay,
Thank you so much.
so yeah, so and really it's a fantastic, and that the it's all about the systematic violence, because I am also teaching the IR, and I'm very curious to solve all these issues, because every time when you talk about the Africa, we talk about the India, we talk about the Asian countries or the Caribbean countries, we talk about the violence. But how you prevent all those violence? This is because this is the time is gone that a research scholar would only think about the methods and methodologies. But right now we have to think about the some remedies also to find out, because the talk it was violence to scams. Yes, this is the need. This is the reality of the situation. But how come we came out from all these things? So this is the new idea. That means from the scholars, from the professors, they came out new ideas. So as these days I'm involved in the teaching also, the functionalism or constructivism theory of IA. Likewise, we can use, this is the right time to we get away from the realism and move further for the functionalism or constructivism theory of IA. So this is the, because most of the students I counted in my department, they are from the political science. Uh, so this is the right time to inculcate, and the department where I'm right now I'm teaching, it's area studies, the history student, the political sciences, the sociology student. So this is a very interesting hub to understand each other and the every subject nuance. Came out with some solution, only talking about the problems. And though I'm not pointing out this, yeah, your topic was wonderful and also Ruchi, but now this time that the scholars and the teachers came out with some solution. Otherwise, in the coming 20 more years, we can talk about the legalities and violence and little, and Lebanon, Gaza, Palestine, Israel, they are what they are involved in the war. And this is the again Eurocentric. Europe never wanted the war happens in their own land. Every war away from the Europe, for the Europe and by the Europe. One point, this is the, we do understand the things that Europe in on the Europe land जो काफी कम वॉर होते हैं यूरोप के लिए, यूरोप के द्वारा war होता है कहाँ पे, outside the Europe. So now these days what is happening for the European continent, war is going on in the Asian continent. So and in 1880s or 1819 it was the African continent. So this is the very right time to understand the Eurocentric approach of the world and get away to all those ideas. Okay, so when the Britishers came to India, what happened? The culture of status become the culture of contract. And for India, here we start the facing the problem. They did not have any written constitution, and they gave us a written constitution. This is the first fundamental ideas, and the government, the today's government, they are trying to reduce the redundant laws. So it's a very fantastic they are doing so, but again there were so many problems. So what the culture of status moved towards the culture of contract, and the problem was started only there, because the manner you treat your native, this is the most important thing. This is the most important thing in any part of the country. So we learn how to behave, to the other. This is the most important for the international relation theory also. So I have so many things to say, but clock is ticking towards 6 o'clock, and we are uncertain rule that written rule that we have to start 5 and try to end 6. So thank you very much, my two English scholars, and you portray so many things. And the violence to a scam, the next scholar is going to talk about the scams, and with these young scholars. And one very important nuance, because Drishya told that she was from South India, a very important book, Malabar and the Portuguese, K.N. Panikkar. And the first time K.N. Panikkar wrote about the Portuguese, and he wrote Culture of Terror. So the Portuguese introduced about the culture of terror on the coast of the Malabar. So thank you, Drishya. Thank you, Richie. And the coming
Thank you.
speaker from Dolatram College is going to talk on the scams. So really, it's a wonderful evening, 5 to 6. Every Sunday, it is a fantastic idea. So thank you very much, my all graduate, postgraduate, MPhil and PhD students, my seniors, my colleagues, and my dear friends. So thank you very much. We'll meet next Sunday. तब तक के लिए signing off. हम सब अपना काम करें and try to find out a real solution through the international relation theory. Theory is not only to read, write, and marks. It's must for the implementation also. Thank you. Have a nice day. Thank you. Thank you.